reference to what was termed to be the running down the passage, and I think we should before you.
Yes.
We're in possession of the unofficial clear that Professor Dermond was relying on a statement, the import of which was that he had read somewhere that somebody had run. The automatic response to that is, by Mr. Nell, no, please, Professor, think carefully. At that point in time, it's not a situation that the professor suggests that there was a running down the passage on the approach path to the bathroom. What he said was that he had read somewhere that there was a description of running. Now, it goes further. Professor Dermond also says, I don't say that that was where I saw, quote, I ran, unquote.
Lennon zips it into Modric, and Spurs are in front. Fantastic finish on Luka Modric, his fourth of the season.
Once there was an appreciation of the fact that confusion may have crept in, was then to have put the correct caption in the record to the witness. That was the objection, my lady. Otherwise, and then later on, the state would want to argue that it was contradictory, when this entire difficulty and confusion could have been avoided. That was the objection, as the court pleases.
Thank you very much, Mr. Aldridge. Yes, Mr. Nell.
May it please the court, my lady. Mr. Aldridge on Thursday demanded an apology. I don't owe anybody an apology, and I'll go through the record. I don't demand an apology, but let me go through the record.
Well, was it here in court?
Yes, he said Mr. Nell should apologize. on Thursday?
I missed it.
I never said that.
I must have missed it.
Lady,
It doesn't ring a bell.
may I deal with the
Yes,
objection?
please
The
do.
official record, page 2893. It starts. But may I just have a word? May I just have a word with somebody behind
Yes,
me?
before you do, did you say 289?
2893, my lady.
93, thank you. Yes, you may consult.
My lady, the reference that's important is I put him at line 1, 2, 3, at line 4. Let us deal with it, as well, please, my lady. I will rephrase.
Are we just 1 minute? Are we dealing now with Thursday?
No, we're now dealing with the objection, my lady,
Yes, the objection on Thursday.
on Thursday.
Yes.
Indeed, my lady. The accused armed himself, make his gun ready to fire, walked down the passage, had a lookout for people that may come from the front. What is his intention now, as far as you're concerned? That's a question by me. The response is, as far as I understand it, and this was where I specifically asked him, because one of the elements in the record was a comment from the accused saying, "My lady, I ran." And that is what I did not understand, and that is why I wanted to speak to him again, because I did not understand it. My point being, I asked no question about ran. The witness volunteered this line of questioning. No. Then I said no. The witness responded, line 12. So I understand that he moved down this corridor. I was interested in how he moved, but it's important. So I understand that he moved down this corridor. I was interested in how he moved, and I understand that he moved on his stumps with one hand against the wall, with the other hand out in front of him. We're dealing with a corridor. I followed it up. Did you read that he ran down that passage in the record? The answer. There was a statement at some point in time saying, "I ran." Then, my lady, lines 23. I say, you see, that is because we don't have all these notes. There is nowhere in the record or in his evidence that he ran down that passage approaching the bathroom. Nowhere. Why would that have concerned you? So, my lady, there could have been no misleading of this witness. Every time I referred to running down that passage or down the corridor. Mr. Aldrich now got up this morning, and I can still remember this morning, when he said, the way I framed the question could be perceived to be misleading. Lady, I've now read. I've never referred to running without referring to the passage. Then, at page 2894, the answer by the witness. Because, sir, that is, my lady, that is when I asked him how he moved, because that was the purpose of bringing him back to see me, because I wanted it clarified. But I know that he moved down that corridor. I do not say that is where I ran. In fact, he stated to me that he moved slowly down the corridor with one hand against the wall with a gun in hand. I'm reading large sections of the record, but otherwise it would not make sense. It was followed up. You see, I find it interesting because, in fact, you stopped me and you wanted to tell the court that this is the one aspect that you dealt with, and I'm now telling you, I don't want to confuse you. You stopped me and you wanted to say there's one other thing that you want to tell the court, and that is the ran. The witness answered, no. I was explaining to you why I brought him back. And when he described to me how he moved at this point in time down the corridor, I then said, because you read somewhere that he said he ran down the corridor. Yes. Where did you read this? It was in the record. My lady, the objection was that my questions may have been misleading. my lady, every time I referred to running in this instance and where it started, I referred to running down the corridor. I'm just, and that is when Mr. Aldrich got up. My lady, I have not in any way asked a question that could be perceived as misleading. I referred in all my questions to running down the corridor. I used it because it was initiated by the witness. Therefore, my lady, I don't think it was an unfair question. As the court pleases.
Thank you. Yes,
My lady,
Mr. Aldrich?
I need to simply make reference to what is to be found at the tail end of Mr. Nell's submission when he says, I never said down the corridor. The point is simply this, and the record goes even further. Mr. Nell puts it that when on the first occasion from the bedroom he ran to the bathroom, you read it somewhere in the record, and I'll go further yet again. Firstly, you yourself linked the ran evidence to this occasion when he armed himself and he was on his way to the bathroom. Now it must be, with respect, very clear that that is misleading. Because there was running on the accused's version from the time that he had armed himself to where the passage begins. If Mr. Nell knew, which he did, that there was only a reference being made to running down the passage, and why is it not that he puts that to the witness? He says all he speaks to is the running down the passage, but when we look at that very first caption that I've just quoted, that's not the case. He speaks to running from the time that he armed himself in the bedroom to the bathroom. And we know that the evidence is that after he'd armed himself, there was running to the beginning of the passage. That is the reason why we have this misleading event and uncertainty, as the court pleases.
Just 1 minute. Just 1 minute. Are you saying it's misleading to ask whether the witness got run from the record?
No, my lady. No. And I come back to what I'd originally said. Mr. Nell asked the question, did you read that he ran down that passage in the record?
Yes.
And then the witness responds and he says, there was a statement at some point in time saying, I ran. Mm-hmm. So he had picked that up in the record, and correctly so. Mm-hmm. But what he had picked up was the reference by our client, the accused, to say when he ran. And that was from the time when he had collected the firearm on his approach path to the passage. So there's two very distinct issues here. And that's where the confusion comes in. There was indeed running on the evidence that took place, from the bed to the passage, but certainly not down the passage. In other words, the evidence was clear in that regard.
I'm trying to digest what you say. Are you saying Mr. Nell said, this is what the accused said?
No.
You're not saying that?
No.
Okay. Then
No,
yes.
that's not what I'm saying.
Yes.
I'm saying the confusion as to when the running took place could have been avoided if it had been put that there had indeed been running, but not down the passage. Because that's not what Mr. Nell had put. But the confusion arose when the professor answered that there was a statement at some point in time saying, I ran. And the immediate response by Mr. Nell is, no, please, Professor, think carefully and just listen to the question. And my submission is, if that distinction had been drawn then to provide clarity and certainty as to when the running had occurred, this confusion would have been avoided.
But it's for the witness to say, well, as far as I can remember, I only saw ran. I'm not sure whether it was before or after.
That's what he said. That's what the witness said. He said at that stage, all he could recall that was that he had read about running. But there was no specifics in his evidence as to when this running occurred, my lady. That was his evidence.
Hold on. So you are saying there's running down the corridor, you don't know whether it was towards the bathroom or from the bathroom to the bedroom.
I don't want to have that confusion reign, my lady. One thing we're sure about is that Mr. Nell had put it that there was running from the bathroom back. And with respect, that's got nothing to do with this incident that I'm referring to. We're merely now talking about the approach to the bathroom. And I'm saying the distinction should have been drawn between running down the passage, which never occurred, as opposed to running from the bedside table towards where the passage starts. That's the confusion. Not at all with reference to the return from the bathroom when there was running. That's my point.
Yes.
So all I'm saying, this is my submission, is if a distinction had been drawn as to when the running had taken place, because, my lady, with respect, the witness
Drawn
could not
by
recall.
Mr. Nell, is that what you're saying?
Yes, indeed.
But Mr. Nell wanted to know where he got run from.
The witness didn't know, my lady, and he said so. He said all he could recall was that he had read it. But there was no certainty in his mind as to when and at which location that took place.
Okay, thank you. Anything else?
Those are my submissions. Thank you, my lady.
Thank you very much. Maybe I need to read the record myself before I can come back to council.
My lady, it is not such an important issue. If I have to say, I could have been more clear, I'll do it, my lady. Because I don't know where this objection will lead to. I would like us to continue with the evidence.
We are going to continue with the evidence.
If the objection is, Mr. Nell must stand up and say, he should have made it more clear. Here I am. I should have made it more clear.
Okay. You're saying there's no reason for me to go back to the record and read it?
If Mr. Aldrich can tell the court what he wants me to say. If he wants me to say, Mr. Nell should have made it more clear. Here I am. I'm saying to the court, I should have made it more clear.
I'm in agreement with that. Thank you, my lady.
Thank you very much.
As a court, please.
I'm indebted to counsel. Please proceed.
As a court, please.
Did I ask you, Professor, if you're still under oath?
Yes, my lady.
Thank you very much.
Professor Durman, let us just deal with some. Start is what your report is not. Do you understand that? It's not a forensic report, am I right?
That is correct.
It is not a report dealing with culpability.
My lady, that is a legal term. I'm not here to speak about culpability.
Yes. It's not dealing with criminal capacity.
No, it is not.
Great. Now, your brief, but whilst we're dealing with a record, and I know I have to admit I was wrong, I want to refer you to the record. You said, Professor Durman, that you read in the bail application of the incident with Gravenstein and De Vares, where the accused got up in a startled response. Can you remember that or not?
Yes, that is correct.
Good. Whilst we're dealing with the record, have you had sight of the record over the weekend?
Yes, I have.
Who gave it to you?
It was forwarded to me by counsel.
So you read the record?
Yes, I've read relevant parts of the record, not all of the record.
If you say the record was referred to you by counsel, what record was referred to you by counsel?
The record of the transcript of Thursday and Friday, and also the record of court proceedings from previously.
Good. Is it still your evidence that you read in the bail application that the Varus and Grywe state described the whole incident where they were watching a movie?
Yes, that is correct.
Is it still evidence that you read it in the bail application?
As I understand it, yes, that is correct.
If I put it to you that you're wrong, it's not in the bail application, what would you say?
I don't know that. All I know is that that is what I have been informed, that was the bail application.
No. So, wait, let me understand that. Okay, let me understand that. You were given the bail application to read.
I was given a document to read.
Now, listen carefully, Doctor. In your mind, you were given the bail application to read, yes or no?
I was given a document to read, my lady.
Why
I
did you-
believe. I believed it was the bail application. That is what I had been informed.
Who informed you that you were reading the bail application?
Counsel informed me.
So, in a document you read, counsel said to you, this is the bail application, and you read about that incident.
That is correct, my lady.
I put to you, Mr. Durman, it's not in the bail record. It's not in the statements attached to the bail record. You are wrong. Where did you get it? What did you refer to?
I have the document with me, my lady.
You referred to statements. Am I right?
My lady, I have no knowledge what they are. I was told it was the bail application. I told you that that was the document that I have.
I find it strange that you would make it so clear and that it's a bail application. I find it strange that it wasn't corrected whilst you gave your evidence.
My lady, that is what I was told.
Good. But that was just because we're dealing with a record. Now, you remember we dealt on Thursday with you being the treating physician and giving expert evidence on behalf of the accused. Can you remember that?
Yes, my lady, I can.
Now, you said that you don't think there is a conflict of interest to be able to do that.
My lady, I believe my report and my submission and my being here is as objective as I can be, and I acknowledge that I am his treating physician, and wherever I can, I've backed up my representation with scientific evidence.
But we know that your brief was very subjective. Or don't you agree with me?
My lady, there were three parts to my presentation. One was my knowledge of Mr. Pistorius. One was my knowledge of disability and issues to do with disability. And the third was the physiology of the flight and fright response.
Now, I asked you a question on Thursday. What was your brief? You remember? You read it in the record.
I remember you asked me that question, my lady.
And you described your brief in subjective terms. Can you remember that? Have you read it?
No, I can't remember it.
I'll read it to you. Page 2850, line 10, my lady. My brief was to detail my experience with Mr. Pistorius. Inasmuch as I have been looking after him for 6 years and my experiences, anything that might be relevant, and then to detail any of my observations with him and anything that I might find relevant to this matter. Now that is totally subjective in the way you described it. Am I right?
Well, I'm not sure.
You're not sure if that's subjective.
Yes.
My brief was to detail my experiences with Mr. Pistorius. That's subjective.
That's subjective, correct?
Inasmuch as I've been looking after him for 6 years, and my experiences must be subjective.
That's correct.
Anything that might be relevant, and then to detail any of my observations, that's subjective.
Well, I think that observations could be objective observations. Typically, as a physician, that's what we do all the time. We make and report objective observations. One is objective in one's approach.
Can I just ask you if, and I'm just asking if, because I have a difficulty with let me rather rephrase. I will argue that you're unable to be objective because you're the treating physician. So I'm going to ask you a question based on that. If Mr. Pistorius was a family member, would you have had a problem in being an objective expert?
Yes, I would have.
Okay. Now we have it. So we have some parameters at least. I would not have given evidence as an expert where a family member wasn't accused. Is that correct?
Yes.
Okay. Now, why would you draw a line between this person, Mr. Pistorius, that you traveled the world with, you spent lots of time with, and a family member?
My lady, very simply, because he is not a family member. He is one of a team of individuals that I travel with. I believe that as a physician, I can be objective. I understand the issue that the prosecutor has, and I believe that I can be, particularly with respect to my evidence that I have rendered in court.
Professor, you're not a psychiatrist or a psychologist, am I right?
That is correct, my lady.
And you will not venture into the expertise of a psychologist and a psychiatrist, am I right?
That is correct, my lady.
And you know that there was a panel appointed to observe the accused in terms of the Criminal Procedure Act.
That is correct, my lady.
And you know that Dr. Fine was appointed by the defense to that panel.
That is correct, my lady.
Have you consulted with him?
With Dr. Fine? I've met once with Dr. Fine.
You consulted with him about his findings?
I have met with Dr. Fine before the period of observation began.
I'm going to repeat the question.
I've
Yes, I know you know what the question is. Please answer it.
I have met with Dr. Fine before the observation began. I have spoken to Dr. Fine after the consultation was concluded.
About his findings?
Yes, my lady.
You commented on Dr. Scholz's report, am I right?
That is correct.
Do you feel yourself qualified to do that?
On certain aspects of it, yes, my lady.
On the psychological test he did, are you entitled to comment on that?
My lady, as far as it goes with respect to the symptom or the construct of anxiety and feeling anxious, yes, I am, because that is something as a physician that I am trained.
I'm asking you if you feel yourself qualified to testify on the results of psychological tests.
In as much as results go, my lady, I would say to have a valid and reliable response to that, you would need to be skilled in psychometric testing.
Now, I'm asking you the question for the third time, and I find it troubling that as an expert you don't answer the questions. Because I will argue, you don't want to. Answer the question. Do you feel yourself qualified to comment on the psychological tests and the results thereof?
My lady, as a clinician, on certain aspects and on reading that the interpretation has already been made. I am commenting on a interpretation of a test. For example, we do a lot of work with concussion, and we have neuropsychological testing. And the neuropsychological testing that we do with relating to concussion is done by a psychologist that is skilled in that. But then they give to me the results of those psychological tests. And then I look at the interpretation of those tests, and I then apply that knowledge as my skill as a physician. So actually I do feel entitled to comment on them, because that is what I do in clinical practice.
But what you did, as far as the Scholz report is concerned, you went a bit further, isn't it? You commented on the result of 70 instead of 71. Are you entitled to do that?
My lady, I merely looked at a cutoff, and there's very clear distinction on where a cutoff is in that.
Where did you get that?
It was in the report.
Can you refer me to it?
My lady, I refer to page 14 of the results.
Exhibit.
Q, my lady.
Thank you very much.
And my lady, there is a preamble on pages 9 through to 13, which describes fully the personal assessment inventory and then the results of the personal assessment inventory. And then it describes quite clearly what the cut-off scores are, which are problematic for diagnoses. And they give the what we call in medicine the reference ranges to those. Then there are the various different constructs going down with the abbreviations so that one can refer back to the various different issues. So there is the meaning that has been interpreted there. And there is the scores going down the side of the page. So,
Is that on page 14 now?
yes.
Yes, thank you.
So I was asked to comment on that particular issue by Mr. Oldwage, and I remarked that 70 is close to the cutoff, because one does not need to be a psychologist to make that inference. I am a physician. I am used to interpreting various different type of scores, from blood tests through to neurocognitive tests, from concussion. And here it's actually put out, it is explained what your cutoff scores are and what they mean. So I am not making any kind of a diagnosis in doing this.
The major issue here is you talk about cutoff, you talk about 71, but you see what it reads is scores between 50 and 70 are viewed as the normal expected. So what we have here is normal. What happens after that is test specific, and you should know the test before you can say 71 means something. Am I right?
Yes, that's correct, my
But
lady.
you did. You did. You said 71 would have meant something in your evidence.
My lady, I'm referring to the paragraph also, 3.2.3, says the score of 70 on ARD indicates although he measures high, Mr. Pistorius does not suffer from a clinically diagnosable anxiety disorder. Now, I am saying that 70 is high. It is abutting on that range. That is what I'm saying.
You see, the question is not that. The question is, you felt yourself qualified to remark on a score of 71. You don't know the test. You don't know what 71 would mean. Because 70 is normal. Why do you feel yourself qualified to remark on that?
My lady, because, and this is why I spoke to Mr. Fine, Dr. Fine afterwards as well, to ask, does he agree that 70 is high? And to find out if the patient was on medication at the time of doing these tests.
Professor, you see, I just want to make it clear. I'm not eliciting hearsay evidence from you about what Dr. Fine said. Because next to me is Dr. Carla Kotze. She was the state's psychiatrist. And she doesn't agree that it's borderline. And?
My lady, it's one thing to suggest that the other psychiatrist for the state doesn't agree. Mr. Nel must be clear to indicate whether it's his intention to call the psychiatrist as a witness in these proceedings.
My lady, I will ask the question in a way that I think I'm entitled to. If there's a view, he can comment on it. If I don't call the witness, it is the court will evaluate the strength of that evidence. But Mr. Aldwych cannot get up and say that I should indicate if I call the witness now. My lady, I'm still formulating a question, and I am careful to formulate the question in such a way that this witness would be able to answer.
Yes, Mr.
I
Aldwych.
note that there's a reluctance to indicate whether Mr. Nel will call this witness. Now, if he doesn't call this witness, is it then fair for the current witness to answer these questions? Because if we must accept his mere say-so, it amounts to hearsay, because there's no way that we can test whether in fact the statement that is being put is accurate and correct. So all we want to know is that witness going to be called? It's as simple as that, my lady.
Mr. Nel?
My lady, I don't know if Mr. Aldwych would now insist that there's a finding. What I will do is, I'll withdraw that question and put it in a different way.
Yes, rephrase.
As good. Mr. Durman, if Dr. Carla Foster would
Professor Durman, my lady.
It's Professor, but it was clearly a mistake. Please proceed.
As a court pleases. Professor Durman, if Dr. Carla Foster would testify that the anxiety is not overly high, he did not test overly high, what would your views be?
If that is indeed the case, my lady, I would cede to my learned colleague's higher qualification in this particular issue, and I know she has had many more years' experience in it than myself, and that is my feeling.
You see, Professor Durman, if I read the record, you indicated that a score of 71 would have constituted a finding. You were qualified enough to tell this court at page 2839, my lady, A comment I would make is just regarding that the markers here, marker of anxiety, namely anxiety ARB or anxiety-related disturbance, is at the borderline. So had that not been 70 but 71, it would have constituted a finding. What finding are you talking about? You don't know the test.
My lady, the test is actually very well explained in the preamble, all the way from page 9 right the way through, with the cutoff values given.
But you don't know what 71 means. Standing there, you don't know the test well enough to tell the court what 71 means.
My lady, for the construct ARD, it says the ARD scale measures clinical and behavioral features of 3 areas of symptomatology related to specific anxiety disorders. It states it quite clearly there, what it's related to. None of this involves me making a psychological or psychiatric diagnosis. In nowhere have I done that and usurped the role of any of my fellow professionals there.
I beg to differ, because, Professor, I'm still asking you a question, which you again failed to answer. If it was 71, it would have constituted a finding of what?
It would have constituted a finding of being high with related to the construct of or the measurement of ARD.
Yes.
So, my lady, the question that I have is that correct or not? That is what I'm now. I don't know. I've answered the question 3 times.
No. Firstly, Professor Durman, as a witness, an expert witness, you would know that you're not entitled to ask questions, but you should answer questions. Do you know that?
Yes, my lady.
Good. I'm dealing with your evidence, sir. You said, in evidence in chief, if it was 71, it would have constituted a finding. Why did you say that? And why do you think you're qualified to say that?
Because the parameters, my lady, had been clearly laid out in the preamble. And my lady knows that these constructs of anxiety are not foreign to me. My lady, I presented work that I have done, research of my own in the areas of anxiety and depression. I presented the abstract that has been peer-reviewed and presented on an international scale. And these are issues to do with things that I'm working with every day.
Okay.
I've done science in this area.
Evidence that 71 would have constituted finding is not in the report by Dr. Scholz, am I correct? Nowhere does he say 71 would have constituted a finding.
Sorry, my lady, I'm looking. I'm referring to this paragraph. It says the score of 70 on ARD indicates that although
what
he
page is
measures
that?
high.
What page?
That is 3.2.3.
It's page 15, my lady.
Now, my lady, here in on page 14, it says results of the PAI. Mr. Pistorius' results are indicated below. Scores between 50 to 70 are viewed as the normal expected response. All the significant scores are indicated in bold. And then it goes on and it says the construct of ARD is 70. And here in 3.2.3, the score of 70 on ARD indicates that although he measures high, Mr. Pistorius does not suffer from a clinically diagnosable anxiety disorder. And I mentioned that if that was 71, then it is a different finding. So with all respects, don't need to be a genius to actually determine this.
One don't need to be a genius, but one need to be a psychologist. You agree with that? I've never said you're a genius or that a genius wrote this. And that is a sarcastic remark, but I take it. But you need to be a psychologist. That you will agree, isn't it?
My lady, as a clinician of 20 years' experience with work and research in this area, I feel that I have the knowledge to say that 71 would have included something else. But I also want to go back to a consultation that I actually spoke to Dr. Fine on this issue.
I'm not interested in your consultation. Don't elicit the hearsay. I'm not. So please deal with the question. I asked you, where did you find 71 in that report? You cannot tell us, am I right?
No.
Good.
71 does not exist in this report.
Good. You also, you do know that the Health Professions Act indicates that tests, measures, questionnaires, instruments that tap psychological constructs must be used, interpreted, and controlled by psychologists. That's what the Act says, am I right?
If you read it to me, sir.
Good. If I'm wrong, Mr. Aldridge will be up.
My lady, I'm hardly in a position to respond. I don't know what it is that Mr. Nell's reading from. Perhaps if he favours us with a copy of this document, we'll then be in a position to respond.
I refer to the Health Professions Act, Act 56 of 1974, that must be available.
You don't have copies?
Not of the Act, my lady. No.
Yes, but it would have been so wonderful if you had copies for everybody so that we should know what you're talking about.
Yes. Yes, my lady. I do understand. I'll make that available. What I did, is I tested this witness's knowledge of this Act, and if he knew that. I'm not going into any detail as far as the Act is concerned at this present moment. If I do, I will make copies.
Yes, can you just make it available to your colleague, Mr. Aldridge?
I'll make the Act available to him. I must just get it, my lady.
No, I mean now.
I don't have it now, my lady.
You don't have it with you?
No, my lady. I've got a document available to me. That I don't think is a problem to make available. The document I'm making available, my lady, is the Professional Board for Psychology, the Health Professions Council of South Africa policy on the classification of psychometric measuring devices, instrument methods and techniques. I will mark the specific portion that I just read out so that it could be checked. Professor.
I'm indebted, thank you.
Sorry, my lady. May I please comment on, as I've been thinking here while listening to argument. My lady, in clinical medicine, there are usually 3 stages of assessment of everything. There's a history, there is clinical examinations, and there is special investigations. Special investigations range, and we use them all the time, anything from a laboratory test for blood work to an EEG that might be commented on by a neurologist, to similar psychological testing that we use in concussion. And whilst I understand that the conducting of the test and the interpretation of the test are the domain of those professionals that do those tests, when they are presented again to the clinician can comment on them and can question them and to ask for clarity on those results. So that is what I'm saying.
Are you done, Professor?
Excuse me?
Are you done?
Thank you, my lady.
Good. Now, Professor, I'm just asking you a question. Do you know that not even psychiatrists will comment on psychometry? It's not in their area of expertise. Do you know that or not?
I do not know that.
But one unbelievable aspect that we tend not to read is page 15, 3.2.3, where the psychologist not only relied on the test scores, but he also relied on clinical findings and collateral information. You agree with that?
I agree.
And in this report, you don't know what that is.
No, I do not.
But still, you thought that you should just... one other thing. At page 14, even in the mind of Dr. Scholz, the 70 wasn't significant. Do you agree?
My lady, he does place that he, obviously it is enough for him to say, indicates that although he measures high, that he has indicated that he measures high on that score.
Remember, I asked you a question. He did not think it to be significant. That's the question. Do you agree with me?
Yes. He states further, Mr. Pistorius does not suffer from a clinically diagnosable anxiety disorder.
No. Let's go to page 14. Results of PAI. Scores between 50 and 70 are viewed as the normal expected response. You have that?
Yes, I do.
All the significant scores are indicated in bold script. Do you see that?
Yes, I do.
70 is not in bold.
Yes, I see that.
So it's not significant. It's high but not significant.
I see that.
Okay. Do you know the DSM-5?
I know of the DSM-5.
What do you know of the DSM-5?
DSM-5 is the latest edition of the Diagnostic and Statistic Manual for psychiatric evaluation.
And all the disorders are listed in the DSM-5.
That is correct.
And you know that the panel of 3 psychiatrists indicated that that the accused did not suffer from any disorders as listed in the DSM-5.
That is correct.
Now, I just want to come back to running. And I'm going to ask you this question, and please, if you don't understand it, let's make sure that we both understand the question. When you asked Mr. Pistorius why he mentioned RAN, he demonstrated something to you.
Yes, that is correct.
Good. And what he demonstrated to you is what you demonstrated to court Thursday.
Well, no, my lady, that isn't. I didn't move out of this witness box. I was here. I
But-
didn't move.
But you indicated, well, you described it, let me just say, it's what you described on Thursday, how he moved.
You asked me to show you how he moved down the corridor. Yes, that is correct.
And that he did on a question to demonstrate to you how he ran. Am I right? You said so.
How he moved, and then he demonstrated to me how he ran down the corridor in chambers. Yes, that is correct.
So, Mr. Pistorius, in fact, described to you how he ran, or demonstrated to you how he
He
ran.
demonstrated to
Yeah.
me how he ran.
He did not say, I never ran, I moved cautiously.
No, I wanted to gauge what he meant by run. Because, as I explained before, my lady, I know that Mr. Pistorius cannot run. Because in order to run, both feet, or both lower limb projections, have to be off the ground at the same time.
Can I just ask you then, was it ever demonstrated to you that Mr. Pistorius was able to walk backwards on his stumps?
It was never demonstrated to me.
You think it's possible?
I've never seen him walk backwards, but I don't see why it should not be possible.
Okay. Apart from the demonstration in the corridor, did you see any other demonstration of the accused running?
No, I have a number of times when we have been travelling, seen him moving on his stumps from bed to bathroom and around his room. That is the only time I've seen it.
Do you now, in your explanation of the demonstration, the accused had his one hand against the wall. Am I right?
Yes?
In all demonstrations that you saw, he had one hand against the wall.
No. When I saw him, when I asked him to show me what he meant by run, he didn't have, yeah, I'm not sure if he had both his hands against the wall when he was running.
No, you see, why would you not be sure? You were there. You volunteered the evidence.
I know that his hand was against the wall when he was walking. I'm not sure if he was running. I can't recall, my lady.
Okay, then at least we have this concession. I don't know if he is able to run without having his hand against the wall. Am I right?
I cannot be sure, my lady.
What? Well, then the answer is yes, I don't know. Why is the answer I cannot be sure?
Because that's how I answered it, my lady.
No, the answer is, the question is, you don't know if he's able to run without having his hand against the wall. The answer must be, yes, I don't know. Can we have that answer?
Yes?
Okay. I said, can we have the answer? Is the answer yes to I don't know?
Yes, I do not know.
Okay. Now, just think back. Your demonstration of the accused running, his demonstration to you, the gun must have been in his right hand, am I right?
Yes, it must have been. But I'm thinking now, in fact, if when I asked him to run, there was no gun at all. Can't even remember if his hand was outstretched like this when he was running. I asked him to run, but I can't remember if there was a gun or he held his hand out like in a gun.
You see, I find this answer interesting. But let me just unpack it a bit. When he walked, at least he had the gun in his right hand. Demonstrated the gun to be in his right hand.
Yes, he did.
You see, Professor, let me just get to the specific evidence. Later, I'm just paging through the record. I'll proceed now. I will get to, during the break, to the record, or we'll get to the record now. My recollection is, if I'm wrong, I'll apologize again. When you asked him how he ran, that gave rise to the demonstration that you explained in court. Am I wrong in saying that?
Could you put that to me again, sir?
You asked him a question. You wanted to clear up the fact that you read in the record, I ran. You asked him about that. And he demonstrated to you how he ran. And that is what you explained to court.
Yes, I asked him, my lady, to show me how you run as fast as you possibly can. That is what I asked him.
And when he did that, is that what you explained in court on Thursday, or not?
No.
Not. Okay. 2894. So what did you describe in court on Friday then? Oh, on Thursday.
I explained how he showed me how he moved down the corridor.
You see, I'm going to refer you to the record, to page 2904, my lady. At line 7. Earlier, my lady, at line 4.
At line?
Will you follow the record,
4.
please, Professor?
Did you say line? What line?
Line 4, my lady.
Thank you.
Now, I must just understand it. When you asked him about running, there is some demonstration of him walking with his hand against the side structure. Do you have it with you?
Can you give me the reference, please?
I don't think we've got the same, but mine is 2904. But I'll make it easier for you. I'll send you
Thanks.
record. Do you have line 4, Professor? Start with no, can I?
Yes.
Okay, let's just read it. Now, can I must just understand it. When you ask him about running, there is some demonstration of him walking with his hand against the side structure. Am I right? Or am I wrong? You say yes. Now, that demonstration was in response to your question about running. Yes. Now, then I say, no, is that so? It is in response to show me how you moved and show me how in what position one walked or one moved, and I ask about running. Show me. I wanted to see what he means by run down the corridor. I make the inference that when you ask him about running, that's what he showed you.
My lady, my response to that is this is very confusing here, first of all. The part that Mr. Nell read to me was, no, I must understand it. When you asked him about running, there's some demonstration of him walking with his hand against the side structure. Am I right? Question mark. Am I wrong? Question mark. And then the answer is yes. I don't even know what that yes is to. But what I am trying to say here is that there were, when I asked him how he moved, there are two separate things that I asked him about. I asked him to show me how he moved, and then I asked him to show me how to run as fast as he can. So that is the truth of the matter. Now, I'm not quite sure what the prosecutor is inferring from this area here.
You see, it goes further. Line 20. Let's make it line 18. I was specifically interested in knowing how you're able to run on his left stump because I know about that left stump. I wanted to see how this running was. He showed me how he moved down the corridor, and I remember and recall quite clearly how he had his hand out in front of him and how his hip was in external rotation, so that he could hold that area of his left stump in an area that was not on that very painful area. That is, he showed me how he moved down the corridor. I then asked him to show me what's the fastest that he can run, and he demonstrated how he ran. In fact, the question after that, have you shown the court? So, this walking down with one hand on the side of the structure is not running.
No.
Good. Do you know when he ran on that night?
It's still not clear to me.
You've read the record and it's still not clear to you.
I have read the record, but if we want to go and speak about that, if we can have the record in front of us, and then there will be no confusion.
And I'm asking you, as you stand there, you're the expert, you're giving evidence. Do you know, and what's your understanding, when did you run on that evening?
My lady, I am not an expert in this record. I'd want to have the record in front of me.
You're welcome to. As you stand there, what is your understanding, when did you run?
There was a mention of running before he got to the corridor, and then at some stage later there was a mention of running, if I recall, back to the bedroom.
Good. So at least in the accused mind, he ran on that evening.
Yes.
Now, did you ever see, well, when he ran, when the accused showed you how he ran with his hips and shoulders facing to the front and moving as fast as he could forward. There was no rotational movement. Am I right?
I don't get the question.
The question is, when he demonstrated to you how he ran with his shoulders and hips facing the front without any rotational movement of his hips. Am I right?
Well, when he runs, he does hold the right leg at a certain angle, so particularly the left leg, so he does not touch that painful area on the end of the left stump in contact, and that makes there is an angle that I've seen on their hips that then that changes his leg length position, and that makes him a little bit like smaller.
Yes, but he's running with his chest facing the front. Am I right? That's possible for him to do, and his hips.
Yes, that is.
Okay. Did you not see him running like that with his hand lifted up?
No, I haven't seen that.
But that would be possible as far as you're concerned or not?
Don't suppose why not? It would be difficult to balance like that.
But you don't know if it's possible or not.
I don't know. I certainly didn't ask him to run like this with the hand out.
Good. Now, Doctor, Professor, I apologize again. I've looked at your supporting documents, and I just want to touch on one or two aspects of those supporting documents. Now, firstly, and we'll get back to this, page 24. Do you have it with you?
I have it.
Good. So it's mark 24. And more particularly at the bottom of that page, where it's described, this sympathetic system promotes responses that prepare the body for strenuous physical activity in the face of emergency or stressful situations, such as physical threat from the outside environment. This response is typically referred to as fight or flight response because the sympathetic system readies the body to fight against or flee from a threat. So in fact, that's a positive survival tool that we have as humans.
Yes, that is correct.
Yeah. So that would cause you to run faster than you think you could, than you normally would be able to. Am I right?
Yes, that is correct.
Have more power than you think you were, like, lift a car up and all those kind of things.
That is possible.
Also being vigilant, knowing exactly what is going on around you. Am I right?
Well, my lady, as I explained before, when the amygdala is triggered, speed is what the amygdala uses at the expense of accuracy. So we know that there is decreased, from many imaging studies of the brain, there is decreased activation of the cortex. So in fact, thinking is less. And the example that maybe I can give that is understandable is if I'm standing close to a road and a car comes along and nearly hits me and we jump out the way. The response of the body to get out of the way hasn't had that cortical kind of planning and executive function that has got us out of the way. It's been like an automatic thing that has happened.
But that's immediate.
Yes.
That's immediate. That automatic thing is immediate. Am I right?
Yes.
Okay. But now, this flight or fight response is a normal physiological response, and it's present in all people.
It is indeed.
Now, even on the objective facts, there was at least an option for the accused to flee, even walk out of the room. Am I right? On the night of the incident.
There indeed is that option.
Yes. Now, I will get back to this. I was just indicated to you that I'm dealing with the documents that you attached. And if we could just turn to page 31.
My lady, can I just go back and just refer to Mr. Nell's last question? He asked me, is he able to flee? I would like to say that he is able to flee in the best possible way that he is able to flee. Might be very different, and as I've explained, the ability to flee like we would normally flee, as in you or I, is different. And I don't want that to be considered that I've answered that question, that he can flee and move rapidly like any of us can.
He can walk out the door of the bedroom. Walk.
He could walk like he could walk.
Yes.
At his pace, with his limitations, yes.
Indeed. He could walk at the same pace that he walked earlier that evening to brush his teeth in the bathroom. He could walk out the main bedroom door. That was available, that option.
Yes.
He could have. It was possible to hide in the room. It's possible. I'm not saying what he did. It was possible for him to hide in the main bedroom.
It's possible.
Yes. Now, when there's a startle, you would expect a heightened sense of awareness, at least.
When you have a startle, the startle is a very, very rapid response. So it is a response that it primes the system. So it's that auditory or shock stimulus that the body has that startle response where the eye blinks, where the body goes into a flexion. And then what happens after that, the brain does have that awareness that Mr. Nell speaks about, that it actually assesses the surroundings, and it now matches the threat with the experiences that are programmed into the amygdala that we spoke about so much on Thursday and Wednesday. And then if that matches the experience of the amygdala, then that flight and fright response ensues.
Yes. So the fact is there would be a heightened sense of awareness. The answer is yes.
Yes. Why I am hesitant here is that we do know that when this is happening, there is decreased activation of the cortex. And I spoke about that ventromedial prefrontal cortex hippocampal tract that is activated at that time. So we do know that that happens. To what extent, I do not know. To what extent that this executive functioning of the brain is inhibited, it varies in various situations.
I perhaps failed to ask you a question earlier on. You view your evidence before court as being objective as you can be.
Yes.
You've never once considered that the accused version might be a lie.
So, sorry, I didn't hear that.
You've
last
never
one.
considered that the accused version might be a lie.
No, I think that's the wrong inference. Obviously, I have.
You have.
Yes.
That whatever he said was a lie. Did you consider that?
My lady, I'm involved in a court case here where there are two sides. There is state's case and there's the defense case. Clearly, I've considered that there are two sides to this.
But you never addressed the state's case in your report.
In my report,
Yeah. Or in your evidence.
I'm not quite sure what you mean.
No, but did you at least in your report say that based on the state's case, there is no that my evidence would not be important because the flight and fight response would not be applicable?
No, because, my lady, I know that any report that I give is open to cross-examination, and you would ask me anything that you were unclear on.
Yeah. So the answer is you never addressed this in your report, and neither did you do it in your evidence in
No,
chief.
but I never addressed the state's case in my evidence in chief.
Let us deal with page 31 now. This particular article, Prevalence and Risk of Violence Against Adults with Disabilities, a systematic review and meta-analysis of observational studies. Now, I've been through this, Professor, and it's clear, in my reading of it, that it's focused on people with mental illness. The main focus of that article is on people with mental illness.
My lady, what they did in this particular study is they went through, it is a meta-analysis, and they went through various different studies. They started with over 10,000 references, and they culled it down to a whole number of good studies that they were able to use. And they clearly there is more data available in these studies on individuals with mental illnesses.
Yeah.
So that is what I can say. You can see in this particular publication where the data are clearly, when one has more references and more numbers, that is where you get stronger data. So if you have more individuals with mental illnesses, you would get stronger statistical information from that.
You've now given a long explanation. My answer was, the question was so easy. That particular, doesn't mind why. That particular article deals mainly with people with mental illness. Am I right?
No, it looks at various disabilities. There were more individuals with mental illness, but there are various different categories, not only mental illness in this particular paper.
But what we have on page 2, that is, let me rather refer to the page in the record, 31, interpretation. Adults with disabilities are at a higher risk of violence than are non-disabled adults, and those with mental illness could be particularly vulnerable.
Yes.
We'll deal with specific issues, but this is the one study where there's a reference to South Africa. You picked that up?
Yes.
Okay. There is one study from South Africa included.
That is one of the weaknesses, is that we do not have good disability data on this for South Africa.
But the South African study that they referred to, as far as this case is concerned, is irrelevant. Am I right? Because let us just see what it refers to. What was the South African study?
I would need to find that, my lady.
Please do, I did, but please find it. It's at page 48. At 22, number 22. The South African study dealt with abuse of people with dementia by family carers, representatives, and that was a cross-sectional survey. Am I right?
Yes, that's correct.
So that South African study, for purpose of this case, is irrelevant.
Yes, my lady, that's correct.
Good.
However, sorry, my lady, that wasn't the purpose of me showing this. I mean, Mr. Nell is correct in his observations, But the reason I brought this to the attention of the court was to make the point that adults with disabilities are at higher risk of violence than are non-disabled adults. And that is all.
One can also, at the discussion at page 37, it is clear that, at least, let me put it to you in this way. This particular study was presented with other studies that focused on mental illness, and that is why they made the conclusions they did. Am I right?
You're wrong, sir.
Am I wrong?
Yeah.
Okay.
Because, and let me explain, is using the statistical methods that they used, they looked at different groups of individuals and worked out an odds ratio for attack against individuals with disability. So for all the studies combined was 1.31.
Where do you read that?
Sorry, sir. I'm at the summary paragraph, which is right in the front. It's page 31.
Page 31.
And it's the under findings. And it says for all studies combined, the odds ratio was 1.31, which means you're at a 31% increase of attack if you of all the studies. And then it looks at non-specific impairments. And I pointed out in my evidence in chief that that is where Mr. Pistorius's amputation problem would fit in under non-specific impairment. And then for people with intellectual impairments, the odds ratio was 3.86. And that's where Mr. Nell is correct in his observation that the focus is on individuals with mental illness, that somehow individuals with mental illness they bear the most brunt, unfortunately, of violence against individuals with disability.
Now, let us just deal with then the next document you used, and I think that would be at page 61. It has a heading, Crime Against Person with Disabilities, 2009 to 2012, Statistical Tables. Are you there? Page
I'm
61.
I am.
We're dealing with American statistics, am I right?
Correct.
In this whole document, the most prevalent disability victims would be those with cognitive impairment and vision impairment.
That is correct.
Good. And cognitive impairment and visual impairment is not relevant for the current case.
That is correct.
And also in this, we're dealing with statistics here, and it's not legal statistics or court documents that they used in this document, am I right?
Ooh. Now, I would need to look through the methodology again as to how they gauged their violent crimes.
You're welcome to do that. Now, if I read this document, we're dealing with American statistics, granted. There's no indication of where the violence happened, if it was in an institution, if it was outside in the street, who inflicted the violence. Are we dealing with caregivers, family members? That is not clearly indicated in this study, am I right?
That is correct.
Good. Let us go to page 69. The methodology is it's a self-report survey.
Correct.
So you go to people and you ask them questions and they answer the questions. So it's not based in official documentation, American state documentation and or court documentation, am I right?
Yes, in other words, it's not verified.
Yes. Good. Now, you see, my question here is, now that you're in court and that you're giving evidence, don't you think you should have indicated to the court the shortcomings in the two documents that we now dealt with when you testify?
No, my lady, these are what Mr. Nell refers to are merely limitations in the study that was done. And every single study has limitations to it. And if there are limitations that need, if I was going to give you the limitations to each of the papers I would have referred to, there would be many. That is just typically the nature of science. There is never the ideal or the perfect set of circumstances.
Although we're now in a court of law and we're dealing with relevance. Do you understand that?
I do.
Good. Relevance and objectivity. And you did not indicate the fact that this may be irrelevant because of the reasons that I indicated to you.
But, my lady, you know, I have a problem here because this is it's a well-documented publication. I'm looking here, it's actually from the US Department of Justice, and they summarize their findings, that there's a main finding. The main finding, as I brought before the court here, was in 2012, persons with ambulatory disabilities, it was 30 per 1,000, a higher rate of violent victimizations than persons with other such disabilities. And the limitations are in the back. It's not like a major finding of this, that it's such a flawed paper. I wouldn't bring a flawed paper to court.
Can we just also then indicate to the court at page 69 what we're dealing with? At page 69, first column, paragraph 1, 2, 3, 4. Generally, all first interviews are conducted in person. New households rotate into sample on an ongoing basis to replace outgoing households that have been in sample for 3 years period. But what's important now? The sample includes persons living in group quarters such as dormitories, rooming houses, and religious group dwellings, and excludes persons living in military barracks and institutional settings. So, I mean, we have those included, and those samples are not relevant for purposes of this case. Am I right? We're not dealing with somebody living in a group quarters, dormitories, or a rooming house.
Yes, that's correct.
Good. Let us just then carry on and go to page 85. And here I would like to quote counsel for the defense. Aren't you using the study merely to create an atmosphere? And that's not relevant in this particular case at all. Because deal with hate crime, am I right?
Sorry, I misunderstood. Ms. Nell, you said you put to counsel for the defense.
Let's rather stick to questions. This particular article deals with disability hate crime.
Yes.
We don't have it here. There's no indication of disability hate crime in this matter.
My lady, in this matter that is correct. However, what I'm saying here is that this issue to do with people, we're speaking about vulnerability. And we're speaking about vulnerability of people who are disabled, it is a very sad fact that individuals who are disabled suffer more attacks right the way throughout the world than people who are not disabled. And in the United Kingdom, this problem was so great that they introduced this paper and introduced a law to deal with it. And what it does illustrate is merely the fact that people who are disabled, if they feel vulnerable for fear of attack, have got reason to feel that way. That was my justification for showing this to the court.
Whilst you gave that answer, I thought about the word vulnerability. Now, vulnerability should be viewed in the context of the person, am I right?
The person and the situation.
Yes. Because we will find a homeless person on the street, and that person would be vulnerable, am I right?
Yes, sir.
We'll find poor people, and without houses with alarms and guards, they'll be vulnerable.
That is correct.
We'll find older people. Without protection, they'll be vulnerable. Am I right?
Yes.
In this instance, we found somebody with the means to protect himself by living in a security complex and with an alarm system in his house at least. Am I right?
Yes.
We also have a person with a big support group around him, which include family, am I right? And friends.
Yes.
And even you're part of his support group to look after his health.
That is correct.
Now, that whole scenario mitigates his vulnerability in his context.
I disagree strongly.
But we have the person with a gun on the night. If Mr. Pistorius was vulnerable on that night, he armed himself. Am I right?
He did.
At least you will concede. With a gun in hand, he's less vulnerable.
He might indeed be less vulnerable, but how much less vulnerable I do not know. And I can't think if that would reduce his vulnerability. Absolutely.
Now, my lady, it's 12 minutes past 11. I will move to something new. I would prefer to do that after the tea adjournment. Maybe take the tea adjournment now.
Legend for tea.
can you exclude the fact that he wanted to move partly because of the accused being on the phone? Or don't you know?
No, I do not know. And all I can say is from a medical perspective, what I found with respect to Mr. Onufuri, and that I suggested that he move to that room in order to recover.
Have you not had any further discussion about this incident over the weekend?
No, sir, I have not.
Do you know Mr. Onufuri well?
Yes, he is one of the athletes I look after closely at Stellenbosch.
Do you know his family
I know his wife.
and his brother?
No, I do not.
Good. Now, on the night, on your version, there were 3 startles, and those were all sounds. Am I right?
Yes,
Those were the only ones. The startles were all sounds.
yes,
Nothing else.
no,
And the first one was the window closing. Am I right?
yes,
The second one was the toilet door closing.
Closing or opening?
Opening.
Yes.
Opening. Indeed, my lady, open. And the second was the toilet door closing. Am I right?
yes.
What was the third one?
The third sound was a sound from inside the toilet, which was a magazine rack.
We dealt with this on Friday. I just want to ask 1 or 2 questions about this. The fact that it was a magazine rack, where did you get that information from?
From Mr. Pistorius.
He told you that he heard a magazine rack move.
Yes.
He never described that sound in any other way, the last sound.
No, I can't remember.
If he did, would you have remembered it?
No, not really.
Isn't that very important for you in your line of expertise to really know what the sound was?
I know there were 3 sounds.
Okay. But you wanted to know from him what those 3 sounds were.
I wanted to know what his response was to those 3 sounds.
Did you not want to know from him what those were?
And he did tell me, yes.
Okay.
However, my memory is still, my memory of the record and my memory of those discussions is, that wasn't my main focus.
Let us not deal with record. Let us rather deal with your memory of discussions. Because you said to the court now that the accused told you that he heard a sound made by a magazine rack.
Yes.
Now, you don't have any notes on that.
No.
Now, how did he describe that sound, the third sound?
I cannot recall how specifically he described it.
If we don't use the word specific, what did he describe to you?
That he heard a sound.
Okay, you heard a sound. How did it come in that sound was the sound of a magazine rack?
Because that's what I recall that he told me.
I will spend time on this because I think it will become important a bit later. He heard this. He heard a sound. He heard a sound of a magazine rack. Now, what sound would a magazine rack make?
I have no idea.
Now, when somebody tells you, I heard a sound of a magazine rack, what do you think?
That was the sound. I mean, I really don't know how many decibels it was or what nature of it was. It was a sound that startled him.
If you see, a magazine rack in itself will not make a sound. Am I right?
Yes, a magazine rack by itself will not make a sound.
So, what caused it to make a sound? Do you know?
My lady, I assume somebody inside the toilet.
I don't want to assume. I want what you heard from the accused.
I can't recall him telling me that it was somebody. I mean, I assumed that myself. That was an assumption that I made when I listened to him.
So, in fact, if it was a loud sound, soft sound, long sound, short sound, you don't know anything.
No,
You just know it was a sound.
it was a sound and that it startled him.
You see, why do you want to include, and it startled him?
Because that's what I recall he told me.
You can recall it telling you that it startled him, but you cannot recall him telling you what he thought about the sound.
No, I can't recall what he thought about the sound.
See, that doesn't make sense, Professor, because that is more important what he thought the sound was than the fact that it startled him. Don't you think?
No, sir.
Why not? Because he shot and killed somebody. That made that sound.
I understand that.
So why would that not be more important what he thought?
Because there is the legal side to this, and there's the physiological side to this, and it is not my job to interpret the legal aspects of this. I'm here to speak about the physiological responses to a sound.
I'm not asking you to interpret anything. I'm asking you what he told you. That's all. Got nothing to do with legal or physiological. It's a question. What did he tell you?
I didn't hear a question.
Professor, what about the sound startled him?
Sorry, Mr. Nard.
What about the sound startled him?
The sound itself startled him.
He never told you what he thought caused the sound. Except he said it was the magazine rack. But that in itself cannot, so did he tell you what he thought caused it? No.
No, the only things that I could have asked him about the sound was with respect to the quality of the sound, was the duration, the frequency, and the intensity of that sound.
Did you?
No.
Okay. But then, you see, we get to this quite often. I have to go back and get an answer. Because you answered, not verbally, but I saw you shaking your head, saying no. When I asked you, did he explain to you what he thought caused the magazine rack to make a sound? You shook your head from side to side, but you never answered for the record. So the answer must be, no, he never did.
Sorry, we're at cross purposes again.
Okay.
Can you please put your question to me again?
I'm repeating a question
Yes.
where I said, did he ever tell you what he thought caused the sound made by the magazine rack?
The sound made by the magazine
Yeah.
rack. No, he said there was a sound, he thought it was the magazine rack.
You see, so again, please let's deal with the answer. The answer then to my question is no, he did not tell me. Am I right?
Sir, all he told me was that it was the magazine rack. That is all he told me about the sound.
There are two things there. Firstly, I mean, the court asked you to rather address the court and not me.
I am addressing the court.
You said sir.
My lady.
Then, if he said he saw the door opening, you would have remembered that.
No, I don't remember that.
You would have if he said that.
My lady, I was very focused on with respect to the history of those sounds and the startles, not with respect to opening and closing of doors and when, at which stage running occurred and all of these other events. Those are all legal issues. I don't, that is not why I'm here.
You see, sir, I'm surprised by your answer. As an expert, you should listen to the question and answer them. It was such an easy question. If he said to you that he saw the door opening, you would have remembered that. That's all.
I do not remember it.
But the question
And I don't know if he would have said it if I would have remembered it.
Don't you think that would have been very important?
What's your question?
That would have been very important if that door opened. Do you think it would have been?
Yes?
So then, if he said that, you would have remembered.
That he saw a door opening.
The toilet door, yes.
Yes?
So he never said that to you?
No?
Okay. In fact, he said nothing about the toilet door to you.
He told me that the second noise was the toilet door closing.
Okay. Apart from that, now we're now at the third startle. And that's a startle caused by the magazine rack.
Yes, my lady?
So we only had 3. There was no other startle caused by the toilet door.
No?
Okay. Now, being a man interested in sounds, if he indicated to you that there was a sound of the door, you would have remembered that. The toilet door.
Yes?
Okay. He never said that then.
The second sound was the toilet door
No,
closing.
the third sound, sir. The third sound. If he said the third sound was caused by the toilet door, you would have remembered that?
Yes, I would have.
He never said that?
No?
If he said there was a further sound by the toilet door, that's now 3 plus 1 startles, you would have remembered that?
Yes, I would have remembered that.
There was nothing like that?
No?
Okay. Whilst we're dealing with sounds, do you know that the accused's hobby is shooting? One of his hobbies.
I am aware of that, my lady.
And that he would go to the shooting range and he would shoot at the shooting range.
I know so.
And I'm certain you saw the video where he shot the watermelon at the shooting range.
I did.
Now, those sounds would not startle him, would it?
Not necessarily, sir.
Not necessarily. So is it possible that those sounds would startle him?
My lady, as I understand this phenomenon, if one is expecting a sound and is in control of that sound, then it does not have the same startle response as if you are not expecting a sound.
Good. That is the answer I wanted. Now I'm going to go back. I'm standing in the toilet. I think there's somebody behind that door. I'm expecting a sound. So there wouldn't be any startle then.
Just hold on. I'm not clear. I feel.
Let me rephrase, my lady.
Yes.
I'm going back to the bathroom. Third startle. I'm standing in the bathroom. I know there's somebody behind that door. The toilet door.
You think?
Yes, I think there's somebody behind the toilet door. A sound will not startle me because I expect a sound to come from there.
It would depend on what you thought was behind that door.
If I thought it was an intruder, I expect a sound.
No, but that sound is in context with a fear that is programmed into the amygdala.
Yes, but we said now, if you expect a sound on the shooting range, the startle would not be that effective. Now I'm expecting it from the toilet. Why would this now be different?
Because, my lady, on a shooting range, you are in charge of when you discharge your firearm and create the sound.
But I understand the word in charge, but remember you said two things. You're expecting a sound and you're in charge of it. At least you will concede that on your version, the accused expected a sound from the bars.
My lady, maybe let me answer this question in terms of the science, and I take you back to those fear-potentiated startle reactions that I spoke about in my day of my evidence in chief. What we spoke about there is that a sound is used as the main cue for the stimulus for the startle response. And then they do something called the fear-potentiated experiment. And what they do is they put a pad which gives an electric shock onto the subject or the patient's arm here. And then they actually show on the screen different cues, like, for example, it could be a square or it could be a triangle. And they tell the subject who is undertaking this experiment that when the square or when the triangle is flashed on the screen, they know they will get a shock in the next 20 seconds or 40 seconds. And then they measure that startle response. And the results of the studies, as I've shown you on Thursday, show that when you are in a fearful state and you are expecting that noise, but you're also expecting an adverse reaction, the fear-potentiated startle is exaggerated. It's exaggerated. So in answer to Mr. Nell's question, even though there can be an expectation of a sound or vigilance for a sound, it potentiates the startle and makes it worse.
But at that time, we are already acting in terms of a startle. That was the second startle in the passage. He's hypersensitive about what's going on around him. His awareness is higher because of the second startle. Am I right or not?
Yes, that is correct.
So his awareness of what's going on has now been elevated because of the second startle. He's expecting a sound, so the startle would not have an effect on him.
The startle would not do it.
The startle would not have an effect on him.
An effect
An effect.
on him.
Yeah.
My lady, with respect, Mr. Nell has got it wrong. It's exactly the opposite. The startle would be potentiated in the fear setting. It's exactly opposite to what Mr. Nell said.
But I'm aware of what's going on around me. I'm more sensitive because of what happened with the second startle at that time.
Yes, you're vigilant.
Yeah, vigilant. Yeah, okay, good. Now, you made an interesting remark. The shots at a shooting range would not necessarily startle the accused. You used that word, am I right?
Yes,
so is it possible that it might have happened that shots at a shooting range would startle him?
Of course it's possible. If he was not expecting any sounds, similarly for fireworks.
And also, you don't know if he was alone on a shooting range and if other people fired shots at the shooting range.
I do not know, my lady.
Then, we dealt with it quickly on Friday. No, we'll get back to that. The anxiety that we discussed, that's in the report and that you testified about, I just want to ask one or two questions about that. When you tested the accused for his level of anxiety,
Yes,
that was during the athletic season.
that is correct.
And one would expect somebody in the middle of an athletic season to be anxious about the next race and training and so forth.
That is correct.
You did not do any tests after the incident?
Could you clarify which incident?
The 14th of February 2013.
No, I've not done any tests then.
So if somebody scores high on the test during an athletic season, that would be appropriate for the situation.
Yes, it would be. However, what I did present, my lady, was the scores of the Kessler inventory, or the K10, which was done in the 10 days prior to competition. And the point I was making is that Mr. Pistorius' scores were higher than the mean for the whole group of individuals that were subjected to that same amount of stress.
But that's within a context of an athletic meeting 10 days before competition.
Correct.
Yeah. Now, on the night in question, you've read the record and you know what happened when he got home from Johannesburg. Am I right?
From Johannesburg.
Yes. The accused was in Johannesburg, he drove back to his house.
No. Mr. Nell, my lady, I don't have knowledge of that part of the record. I haven't read that. I have not read the entire record.
Okay.
I'm sorry.
Now, if I tell you that the evidence of the accused is that it was a very nice, relaxing evening and he wasn't anxious until he fell asleep.
Is there a question?
If you have that. So we know that before he went to sleep, he wasn't anxious, he was calm. His anxiety, there was no anxiety that we know of.
Not
Does that make an
Not that I'm aware of.
Okay. Now, when you decided to testify, did you do any tests on the accused?
No, I did not.
You used historical information.
Yes, I did.
Did not do any other assessments.
No.
Paragraph 50 of your report. Lady, that's on page 15. You describe there Mr. Pistorius there, am I right? And
Yes.
what he said that he presented with anxiety, coupled with fear.
Yes.
This resulted in a significant flight and fight response.
Yes.
He demonstrated being hypervigilant,
Yes.
has an exaggerated startle response,
Yes.
and has hypersensitive sound.
Yes.
That is the man that we're dealing with.
Yes.
He's a danger to society then, because that caused him to kill someone.
I cannot say that, my lady.
But just look at it. Have you, as far as you're concerned, that is the accused before court. And that led, on your version, to the killing of the deceased.
My lady, that I cannot make that statement. I have got no wherewithal to make a statement that he is a danger to society.
Okay. Let us just say, let's deal with you only used your historical information and you related those to the facts at present. Am I right?
That is correct, my lady.
Now, when we dealt with the video that you saw about the shooting of the watermelon, there was no indication of anxiety and fear present that you could see there. Am I right?
No, I did. I saw that video once, my lady. I can't conclude about psychological status watching that. In fact,
You can't
I
conclude.
I can't even remember if the individual was in full body view. I can't remember the details of that. I know there was shooting. I know that there was a watermelon involved, and I know that there was sound afterwards. There was laughter. That is all I know.
Now, paragraph 54 of your report we should not read into this paragraph that you want to give an opinion on criminal capacity, am I right?
That is correct, my lady. That is not my task.
Or culpability.
That is correct, my lady.
Now, the fact that the accused was able to run on his stumps is as far as he's concerned, in his mind, it's something that you cannot exclude. That in his mind he can run on his stumps.
Yes.
And that he even tried to break down the door whilst on his stumps. You know that's his evidence?
Yes.
That he would be able to do that. He would be able to try and open the door, shoulder the door, or something like that.
I remember that is what he did do.
How do you remember that?
From the record.
You never discussed that with him?
No.
Well, I've neared the end of the cross-examination. May I have 10 minutes just to go through my notes?
We'll adjourn for 10 minutes. still under oath, Professor? Thank you.
That's good, please. Please, just thank you, my lady. Professor Derman, I'm going back to the third startle, the third sound.
Yes, my lady.
The accused never explained to you that he heard movement.
No.
Never explained to you that he heard the magazine rack move.
There was no description of the magazine rack moving it.
But he never explained to
He
you.
said it was the sound.
He never explained to you he heard movement. Now,
No.
am I right?
I can't remember.
But I mean, you were really interested in the sounds. You listened for him to explain the sounds to you. Am I right?
My lady, it was the magazine rack, which was I understood to be the sound.
No. You see, again, let's just deal with the questions. You were focused on the sounds when you spoke to the
That is
accused.
correct.
Now, I asked you a question. If he said he heard movement, you would have remembered that.
Yes.
So then, he did not say to you that he heard movement inside the toilet.
I cannot recall.
You see, it's the strangest thing. Cannot recall means it's possible I forgot about it, if I can't remember it. So I have to task you on it. Why would you use the word I cannot recall?
Because, my lady, that is the truth. I cannot recall.
But if he spoke about movement, it's the sound of movement, that was your focus, you would have remembered.
Yes.
So then we can really forget about the word recall. We can say to this court, he never said to me he heard the sound of movement. Am I not right?
It's like with a double negative. My lady, I didn't get that question.
Well, if you focus more on what I try and say and less on semantics, it would perhaps be easier. Let us start afresh. Your focus in your discussion with the accused was sounds. Am I right?
Yes.
You've identified 3.
Yes.
I asked you if he ever said to you that he heard movement inside the toilet.
No.
You say he never did.
He never did.
Okay. That makes the use of the word I cannot recall by you very interesting, because that indicates your bias for the accused. You don't want to give a straight answer. Why did you use the word I cannot recall?
Because I still cannot recall.
No, but you know he didn't. You just gave me an answer. He did not. Now you want to again go recall. Use the word recall. Why?
That's how it's been put to me.
No. You see, I will go through it again. I have an answer from you. Did the accused ever tell you that he heard movement inside the toilet? I have an answer, no. Is that still your answer?
My lady, Mr. Null has asked me this in many different spheres and over again. My first answer was, I do not recall. I can't recall. He asked me then, if he did speak to me about movement, would I have remembered it? And I think that that is possible. I might have remembered it. But my memory is very fuzzy on this. I think that is quite clear to the court, that I am not certain. That's what I wish to say.
You see, I hear what you wish to say. However, I need an answer. If you, in the one instance, after I pressed you, if you're able to say no, why did you use the words, I cannot recall? That's all. Because you can recall it never happened.
My lady, I cannot recall it. I cannot recall it.
What can you not recall?
Cannot recall that he said there was movement. Do I recall that he said there was movement? No, I cannot recall it.
Just to test you, is it possible that he said that?
Suppose it is, because I can't recall.
You see, that is why, Professor, that is why I take you up on it. You don't want to give an answer that will not benefit the accused. You're too scared to say that he did not say that. Is that not so? Is that
No, that is not true, my lady.
Now, we will argue that the witness called by the defense, Mr. Wolmerans, indicated that the accused aimed at the door at least bullet hole B. He aimed at line of sight alignment when he fired that shot. Do you agree that he aimed for the door?
If that is what is put to me, I do not know any of Mr. Wolmerans's testimony.
But you won't exclude that the accused aimed for the door.
If that is what is put to me, I understand that.
You said so on Thursday as well. He aimed at the sound.
That is what I understand.
And on Friday you went further. Thursday. You went further and you said, let me rather ask a question. Why did you fire at the sound?
To nullify any threat.
Okay. Now, he never identified a threat to you, what the threat was.
He told me he thought there was a burglar in the toilet.
He told you that.
Yes.
Did he explain the third sound, what he thought that was?
He said that was the magazine rack.
He never said that. He said it was the burglar bumping against the magazine rack.
No, he did not say that.
He never said he thought it was the door opening.
No, he did not say that.
Okay. Professor, I have put to you, and I do it again, that you are not objective in your evidence before court. Do you want to respond?
Lady, I have responded to that. I acknowledge I've been in a position of care to Mr. Pistorius for a period of 6 years, and that indeed I've served as his physician, and that I have attempted to come to court to give as an objective opinion as I can. I have backed up whatever I can with scientific evidence, And according to my obligations as a medical practitioner, I have given the best possible evidence that I can. I do not think that I am biased. I believe I have given an objective opinion.
But you that, based on the accused version, if the court would accept the accused version, not the state's version, the accused version, you understand that?
Yes.
He, with intention to kill, shot the person behind the door. That's what he wanted to do, and that's what he did. Do you want to comment on that?
No, I understand that.
Is that all? You want to say understand it? And
Yes.
I put to you that your evidence in no way affects his intention on the night. You have no comment?
But is it my job to do that? Is that not the court's job to do that?
Do you want to respond to what I just put to you? Yes or no? You're an expert, sir. You can say, I don't want to respond, that's fine.
From what I understand, my lady, it was his intention to shoot. That's how I understand it.
I've nothing further. Thank you, lady.
Thank you, Mr. Nell. Yes, Mr. Oldwage.
Thank you, my lady. My lady, I'm going to deal with two questions whereafter I will ask for a short adjournment of 5 to 10 minutes
Yes.
to consider my position. Professor Durman, with reference to the concept of vulnerability coupled with anxiety, can one compartmentalize the existence of that condition into particular circumstances? And I'm going to explain to you what I mean by that. It was put to you that on the evening of 13 February 2013, Mr. Pistorius was, as Mr. Nell put it, not anxious and was relaxed. Do you recall that?
I remember that.
Now, particularly with reference to that which had been put to you, I ask the question, can you compartmentalize when a person is anxious and fearful in accordance with various times or experiences in that person's life? In other words, does that person just become less vulnerable, less anxious when he's relaxed?
No, because there are two recognized constructs of anxiety. There's state anxiety and there's trait anxiety. State anxiety, my lady, is our situational anxiety that we find ourselves in response to certain surroundings. Your trait anxiety is your genetic susceptibility. It's your genes and how we are as individuals because of our makeup.
The second question also relates to what Mr. Nell put to you, that being, hypothetically perhaps, that on the morning in question, our client could simply have walked away. Does that approach fit with what you've described as the fight and flight response?
No, it does not fit that description.
Please explain why not.
is because there is, if one believes that there is a significant perceived threat, one is not going to simply walk away from anything. There is going to be, as rapid as possible, a flight, if that is possible. If one believes, however, that the perceived threat is going to overwhelm you and run much faster than you and actually catch you and harm you, then the fleeing and the flight is not possible. Then we are left with only a fight response.
Thank you, my lady. Might I now ask for the short adjournment?
How short?
5
How
to
short?
10 minutes. We'll notify as
10
soon as we're
minutes,
ready. It shouldn't be more than 5 minutes. Thank you, my lady.
We'll take the agenda. You still under oath, Professor?
Yes, my lady.
Thank you. Thank you, Mr. Aldridge.
Thank you, my lady. I have no further questions for Professor Durban.
Professor Durban, thank you very much for your assistance. You may be excused.
Thank you.
Yes, Mr. Wu?
Thank you, my lady. My lady, this is probably the last witness. We just need some discussions, and we need just to have a discussion with Dr. Kotzer. We have not consulted with her before. She's present today. So I think that's an opportune time. May we stand till 2 o'clock just to make sure that we do not call further witnesses.
Yes.
May I, my lady, whilst I'm listening to what Mr. Roux is saying, Dr. Kotzer is clearly the state's witness, a state psychiatrist. I do not see how Mr. Roux now intends consulting with the state psychiatrist, if that is what he's saying. I don't understand that. So perhaps we should deal with that before we now stand down until 2. I mean, there's a defense psychiatrist, state psychiatrist, a court psychiatrist.
I didn't realize that. I'm sorry. Yes, Mr.
Lady, it's not a state witness. It was the psychiatrist appointed for the state,
For the
psychiatrist appointed for the defense, and one
Yes.
for the court.
Yes.
It's not a state witness, and we're entitled to consult. It's not a state witness. It's just the one that's part of the panel. They brought out the report, and we're in a position.
Just give me 1 minute. I haven't seen 3 separate reports.
That's only one report. That's why.
Yes.
And we just need to sit down with her and get some understanding. We've done it with Dr. Fine, and similarly we want to do it here. It's not a consultation with a state witness. We don't, when it comes to Section 78, it's not your witness. It's a panel appointed by the court, one on behalf of the defense, one of the state. It's very different to a state witness.
I don't agree. The defense consulted with their psychiatrist, which is Dr. Fine, but the state wasn't there. We weren't invited to it. Now the defense wants to consult with the psychiatrist appointed by the state. Why would the defense have a right to consult with a psychiatrist appointed for the state? Would they also have a right to consult with a psychiatrist appointed for the court? Lady, may I take the court back to Mr. Aldrich making it apparently clear? He wanted to know exactly who I'm consulting with, because he said we should not consult with their psychiatrist or the court psychiatrist. That was the intention of the question. Now the shoe is on a different foot. My lady, it's not as if the defense does not have a witness. They do. Dr. Fine. They've indicated to you now they've consulted with him. They must take their decision to call him or not. They cannot, my lady, have a bite at every panel member in consultation before they decide who to call a witness. And certainly, my lady, not with the psychiatrist appointed for the state.
Yes, yes, sir.
There are two main difficulties in the state's proposition, if I may explain it. One, let's go on a pure approach of a state witness. Then there's Shabalala's case. It's very clear. Then the state can be present. I have a right to consult, and the state can be present. That's the first point. There's one more important point flowing from that. Assuming again, and the best argument by the state, that it's a state witness, then he must tell us he's calling her or not calling her. And we know the rule. If you don't call state witnesses, Mr. Nslengethwa, Mr. Rika, Mochwane, then we can call them. And we ask the state to tell us if he's going to call her. And that's only on a pure state witness approach. And if he doesn't call the witness, then that protection is in any event not there. It's in any event not there in Shabalala with the one proviso, then the state can be present during consultation. But if it doesn't call that witness, then we're entitled to consult with that witness and decide if we want to call the witness. It works with every state witness the same way, unless they're called by the state. And that is ample case law on that. So the state cannot call a state witness and then say, I'm not calling her, but you cannot consult with her. And that's why we asked before. Unless he tells us that he wants to call her, then it's very different. Then we'll sit back. But if he doesn't call the witness, then we want to consult, because then it's open for us to consult.
With that much respect, my lady, I don't agree. But what I'm willing to say is, if the defense calls another witness, and that witness is Dr. Fine, in all probability, I'll call Dr. Kotze. It's not, will I call her now? No. The answer is, as I'm standing here, I have to convince the court, firstly, to call this witness. I will do that at the end of the defense case. I don't know if we've reached the end of the defense case. I cannot, my lady, it's impossible for me to get up now and just call a witness. I will have to ask the court's leave to call a witness. But what I'm willing to say is, my lady, if the defense calls Dr. Fine, if they call Dr. Fine, in all probability, I will call Dr. Kotze if there's a need. So it's not as easy as Nglingetwa and those people, my lady. The fact is, we both, Mr. Roo and I, indicated to the court that we accept the reports. We've done that. Based on that, the defense do not have a right to consult with the state psychiatrist. My lady, it is just a matter of fairness even to everybody concerned. Each entity had a witness appointed. Defense, state and court. Why would the defense, my lady, have a right to consult with them all before they call them? It doesn't make sense. The court cannot order it, my lady. What the court can do, with the utmost respect, is the court can indicate that there was a psychiatrist appointed on behalf of the defense. They should make a decision to call it or not, because I'm placing on record. If they call Dr. Fine, I will use Dr. Kotze. I may not call her, because I don't know what Dr. Fine will say. But if there's something there that I don't agree with, in all probability, I will call Dr. Kotze. As a court, please.
Okay. Mr. Roo, is there precedent for what you're asking me to?
Yes, my lady, I can get many precedents. The fact is, the state cannot say, if I can come back to the principle. When there are state witnesses, the state takes statements of many number of persons. Every person not called by the state in the state's case, the defense is entitled to consult with and decide if they want to call them. It's happened in this case. We called the neighbours. They were all state witnesses. It could never be denied by the state. At the moment the state closed this case, the witnesses become available. That's the rule. That cannot be in dispute. Now what we have, we come to the end of the case. I'm not calling Dr. Fine. Before I close my case, there's another person that may or may not be a witness that can be called. We don't know. We haven't consulted with the witness. We ask the state, of course, if you call that witness, then we'll sit back and we can only cross-examine. But if you don't call that witness, we have a right to that witness. The state, otherwise, if it's not so, what the state can do is to get many statements from every possible person, only call 5 persons and say the rest are protected.
But we are talking in particular about an expert who was appointed for the state.
That's what I was saying. I say in the first place, as a panel member, there can't be an objection that we consult with her. If the state wants to make her position as exactly the same as a state witness, it's in any event available. But We cannot be denied to consult with the witness unless the state indicates to us that he's calling the witness. He says, well, if you're calling Dr. Fine, then I may want to call her. We're not calling Dr. Fine. Now, if we block to consult with the potential witness that the state's not calling, I mean, that would not be fair. There's no basis to stop us on that.
Yes. And you said there are precedents. Any case in point?
Any case in point on a state witness not called by the state?
No, I'm not talking about that.
I don't know of any case saying that if the state does not call a panel member, I don't know of any case dealing with that specific. It's a principle.
Yes.
So I would be wrong and say there's a case that I can rely on at that point. The case laws, if the state does not call a witness, that witness becomes available. So if the state tells me it's a state witness and it doesn't call it, that witness becomes available. It's that principle. But I don't know. There may be, but I don't know of any case, my lady.
What I saw was one page of the report. Did council have access to a full report?
Yes, my lady, there's the one page by the psychiatrist, and then there's a full report by a psychologist.
No, I'm not referring to the psychologist.
Yeah. No, to the psychiatrist. Yeah, it's one page, my lady.
One page.
But my lady, and it's on that we want to consult. It may not be one page that's only relevant.
That's why I want to know, have you had access to a full report?
No, my lady. It's only that one page. And that's why we need to consult to understand. It's for that very reason.
But there must be a full report.
I don't know, my lady. I
You
would be
don't
wrong in
have an
answering you.
idea.
I'm very careful to make a wrong
Yes.
statement. I don't know. All we have seen was this, and that's why on that report we really need information. Not to say that we will call the witness, but to understand, is that a witness that we should put before the court? Would there be anything flowing from that we must look at or not? We simply don't know. We know it's very relevant, but we don't know how far it will go, if it will go that far, in the absence of that full report. What we do know, if I may assist the court, the only protection is there that it's the accused version to them that's protected, that's privileged. And that's not what we're going to. The Act makes provision, Section 79 makes provision that that's protected for just reasons to put it before the court as through the back door. But that's not what we're asking for. We're not interested in the accused version. That's the only protection that's in the Act.
Mr. Nell, you want to say something before I...
No, my lady, as far as access to reports concerned, that is the report. The one page is the report.
That is the report.
Yes. My lady, am I entitled just to address what point that Mr. Root just made? If it pleases the court. My lady, we're not dealing with a normal state witness by saying, I'm not calling fine, I want to consult with your witness before I close my case. That cannot happen. But my lady, the process is the following. On behalf of the defense, they elected to appoint Dr. Fine to the panel. There was a finding and all three psychiatrists agreed with the finding. So that's a fact. Why would there be a need to consult with a different psychiatrist if you have your own? My lady, if there was something, if Dr. Fine was not available, then we'll wait. But there must be a reason why we don't want to call Dr. Fine. We would rather consult with the state's witness. We would rather have the state psychiatrist. My lady, what's next? Can we now consult with the court psychiatrist? And why is that application not made? And when will that come? It's not an instance, my lady, with the utmost respect, where there is no defense psychiatrist. There is one. He is available. He consulted with the defense. My lady, the state psychiatrist is available for the state to assist the state should the accused attack the findings and or call people. The defense cannot consult with everyone and then decide what they want to do. That is inherently unfair. It's not a normal instance, my lady, where we deal with a state witness. That I agree. It's something different.
Thank you very much. What's the time? I think we'll take a few minutes adjournment.
As a good pleases.
they're going straight to Bongani, so it'll be you very quickly.
And I'm John Webb, coming to you live from outside the High Court here in Pretoria. Welcome to Channel 199 as we analyse the first hour or so of the Oscar Pistorius trial on day 38 of the trial. An element of confusion reigns currently. Will the defence be allowed to call the state psychiatrist, one of 3 psychiatrists who evaluated Oscar Pistorius for the 30 days that he was in Weskoppies? That is the issue that is in front of Judge Masipa currently. She'll rule on that any moment now, or possibly when court reconvenes after the lunch hour. We'll also continue analysing the continued cross-examination of Professor Wayne Durman. A few fireworks there too. So plenty to come from our live position here in Pretoria. But for now, Bongani, it's back to you in Johannesburg.
Following the order of this court in on the 20th of May 2014, that the accused be referred for psychiatric observation. 3 psychiatrists were appointed to assist the state, the defense, and the court respectively. The 3 psychiatrists subsequently compiled a report where they agreed on their findings. This was on the 27th June 2014. When this court resumed last week on Monday the 30th of June, both counsel for the state and for the defense indicated that they were not disputing the findings in the report of the psychiatrist. The defense then led evidence of other witnesses. Defense counsel at this stage of the proceedings has stated that he needs time to consult with Dr. Kotze, appointed to assist the state, before he decides whether or not to close the defense case. Counsel for the state has objected to this request on the basis that Dr. Kotze was appointed to assist the state and that the state has consulted with her. It is common cause, however, that the state is not calling Dr. Kotze as a witness. Counsel for the defense argued that the defense team was entitled to consult with any witness that the state is not going to call to give evidence. He, however, could not refer this court to a case in point where such a witness happened to be a member of a panel. I am not persuaded that Dr. Kotze falls within the category of normal witnesses called by either the state or the defense. I'm not even sure whether it would be in the interest of justice to allow this to happen. Dr. Kotze, as well as her 2 other colleagues, were appointed to assist as stated above. They are neither for the state or the defense in the normal sense of the word. The fact that Dr. Kotze is here present in court cannot give the defense an entitlement to consult with her. The report is 1-pager. If the defense really wants to clarify any issue contained in that report, that is Exhibit PPP, all they have to do is to consult Dr. Fine. In my view, no basis has been laid for the request to consult with Dr. Kotze. For that reason, my ruling is that the defense is not permitted to consult with Dr. Kotze.
As the court pleases.
As the court pleases, my lady. My lady, I'm not bringing an application to consult with the other psychiatrists. Lady, would you grant me an indulgence? I can say prima facie, we plan to close the case. I just need to get proper instructions. Can we stand till tomorrow morning, my lady, to just confer with everyone around me and to make sure that it's the right move?
Mr. Nell?
I think it's a reasonable request, my lady.
Okay. Thank you very much. We shall adjourn until tomorrow at 9:30 in the morning.
As a good business.
On second thoughts, I'd like to see counsel in my chambers. Thank you.
We will.